Welcome, everybody. We're really excited to have you in class today. My name is Curry Sotner. I'm the Chief Learning Officer at the National Constitution Center, and I'll be your kind of like host, moderator, and guide for this class today, all about the Supreme Court. We're also with Tom Donnelly. He's one of our top scholars at the National Constitution Center, and he's going to give us the 101 nuts and bolts as well as the current cases on the Supreme Court. So I love the classes when we do it like this. It's always what I call the how stuff works class. And so let's dig into the court, how it works, what the jobs of the courts, how the court structures is set up, and then some of the court cases that we're going to be hearing in the news in the next 4 weeks. So what a fun class to go through the history all the way to literally the current conversation on the courts. So Tom, what do you think is the big idea that after this class, the students will be able to walk away with?
Well, I mean, I hope that, at one level, Curry, that there's a way in which I think that the Supreme Court and the federal courts can seem a bit mysterious, a bit intimidating. And I hope that one thing we can do is to try to, sort of move, shift the curtain away, get everyone to see exactly what it is the courts are doing, how they could really sometimes look past legalese, legal jargon, and just really know the nuts and bolts of how the courts work. The big idea here, Curry, is of course, the absolute basics of what we see in Article 3 and in the court's real power, which is one, the federal court system is established by Article 3 of the Constitution. And so this is a different branch of government. It's a branch of government responsible for interpreting the law. And so that's the key core function that we're seeing in the federal judiciary. But as we look into Article 3, as we look into sort of the nuts and bolts of what's established there, we see a couple of other big things. One thing we were really committed to in creating the federal judiciary, including the Supreme Court, was this idea of judicial independence, which we'll return to a bunch of times today. And this is this idea that we want the federal courts to be separate from the elected branches. And the reason we wanted this was the founding generation, they remembered the courts of the crown, of the British Empire. And those judges were, the king and parliament could kick them out of office. They could take away their salaries. They really were dependent on the king and on parliament. And when we set up our courts, we said, we don't want that. We want a separate body that's separate from the elected branches. And so therefore, judicial independence. How do we get this? Well, the really, really big way is that we have life tenure for Supreme Court justices and federal judges, which means that they serve until they either resign, they choose to resign, they die, or they're impeached and removed. And so they really, really can serve for decades upon decades. They often serve for way longer than the presidents that have appointed them. And so because of that, it ends up being such an important part of our constitutional system. The last thing, Curry, is what sort of power do the courts have? When we think about the power of these courts, the big one for purposes of the Constitution is the power of judicial review. And so this is that power that gives the federal courts, the Supreme Court, the ability to look at a law and decide whether it's constitutional or unconstitutional. So those are just a real top level sort of nuts and bolts. That's the big structure. And everything we're going to talk about after that is about sort of the mechanics of then how the system works.
I think that's awesome. And understanding what's their job, how they are a full-fledged part of the three branches of government, and what's their role in that balancing act. But it is really the nuts and bolts that people don't ever get into, which is why I think I love this class, because we're going to get really into the weeds and walk around it. And students, as we do this, if questions pop into your head and you want more information about this nuts and bolts, ask them in the chat. We've been loving it in these classes all week. Students have been asking lots of really good questions that have been lingering in our minds, but then you just sometimes forget to ask. So share away. Now, Tom, we'll start with the family photo, is what I like to call it, of the Supreme Court, or their class photo. We look at the court, who's on the court right now. We see 9 justices, but they're definitely not in order of height. So how are they arranged in this sitting, and how does the arrangements matter?
Yeah, absolutely. So here we see 9 justices. We have a full court. One thing to note is that the Constitution actually leaves the number of justices to Congress. And so again, one final thing to note about the Constitution is that many of the details of what we talk about here aren't actually in the text of the Constitution, but instead the Constitution gives Congress a lot of power to determine big things about the national courts, including how many justices we have. And so we've had as few as 5, as many as 10, and it's changed over time, but we've had 9 for 152 years. So we've gotten used to sort of this looking like a full court. So how are they sitting here? Based on seniority. And so if we're looking at the picture, just walking through the picture we have here, the most senior justice is always the Chief Justice. Whether the Chief Justice has served for a month or 30 years, that justice immediately as they become chief is the most senior. We'll talk about why that's important in a little bit, but that's Chief Justice Roberts right in the middle there, appointed by George W. Bush. And then you see number 2 there is Clarence Thomas, the next most, that sort of second in seniority, appointed by George Herbert Walker Bush. Number 3 is Justice Stephen Breyer, who was appointed by President Clinton and is going to be our guest for our Friday class next week as sort of the finale to these courses for the year, but that's Justice Breyer. Number 4 then in seniority is Justice Samuel Alito there on the bottom row. And so Justice Alito he was nominated by President George W. Bush. And then if we go all the way then to the next end there, number 5 is Justice Sonia Sotomayor, who was appointed by President Obama. And then we go into the back row, number 6, also appointed by President Obama, was Justice Elena Kagan, who generously did some educational videos for us on the First Amendment. It was absolutely terrific. So you can check those out on our website. Number 7 then, the next most senior, is the first of President Trump's nominees, which is Justice Neil Gorsuch. And then number 8 in the back there is also appointed by President Trump, Justice Brett Kavanaugh. And then finally, the most recent justice, the most junior justice, is also appointed by President Trump. It's Justice Amy Coney Barrett. And I always like to tell the story, part of, with the justices here, why does seniority matter? Well, one, small but kind of funny reason is the most junior justice on the Supreme Court is actually responsible for answering the door during the Supreme Court justices' conferences, because the conferences are in secret. No one else is allowed in there, not law clerks, not assistants, not police officers. No one's allowed in there except the justices themselves. This is when they talk about which cases they're going to take and how they're thinking about the cases that have been argued. But when someone knocks on the door, maybe for food delivery or a paper, who knows, that junior justice, it'll be Justice Amy Coney Barrett, will go to the door to answer. Justice Breyer was actually the junior justice for 12 years. So he was responsible for that for 12 years, Carrie.
It's almost like, like a nice form of hazing. Like they had to get the door. A couple questions around, and by the way, Justice Gorsuch, he did videos for us too. So we'll make sure we send, and you're right, the Kagan videos, the Gorsuch videos, they're awesome. So we'll make sure we send them out in the wrap up this week. So Tom, thank you for saying that and reminding me. When we think about like who is on the courts and the numbering of the courts, it kind of always makes me want to ask also, so much of what we see of the courts is what they write and how they write their opinions and their dissents. And then other words like concurrences, there's all these fun words that are around the levels of feedback that they give when they decide a case. So I thought maybe we could talk about who writes them, in what order, but at the same time talk about how a case comes to the Supreme Court and the process of going through the Supreme Court directly.
Should we start just with a quick overview of the different levels of the federal courts, then we can talk about what happens at the Supreme Court?
Sure. So do you want to, actually, before we do that, do you want to dive into when we think about Article 3, when we set that up just for like a hot second look at Article 3 and talk about, it's not just the Supreme Court, it's the Supreme Court and the inferior courts that it sets up. And this is what gives the judicial branch the power to set up these lower courts, right?
Yeah, so Article 3, it does an interesting thing. So when we think about the Constitutional Convention, the delegates spend a lot of time on Congress, on representation, battles over the institution of slavery, even the presidency, but they spent very, very little time on the judiciary. And what they decided to do is to come up with a compromise there. And we have it here in Section 1 of Article 3, which is to say, 1, we're going to have a national judiciary. So under the Articles of Confederation, the government that was before the US Constitution, we had no national judiciary. So the founders are making a real decision here in Article 3 saying, no, we are going to have a national judiciary. And what is it going to look like? Well, we know we want one Supreme Court. So we definitely want to say that there's going to be that. We're going to say that in Article 3. But at the same time, we're going to leave all of the other details, including what other layers of national courts, we're going to leave those questions to Congress. And so Congress could leave it at a Supreme Court with no lower courts. It could have a Supreme Court with multiple layers of lower courts. So that ends up being a decision Congress has to make over time. The first Congress under the new Constitution, one of the first things they do is they pass a federal Judiciary Act setting up the judiciary. And so saying how many justices there'll be. And they also created one layer of lower courts beneath that of district court judges. But this would change over time based on what Congress decided.
Now, when you look at this layering, and we've stacked it on purpose, but the cases don't all have to come from the district court straight to the Supreme Court. They could go in different directions, correct?
Well, yeah, the way this will usually work is that, where do cases start? Well, cases so often start with just an individual American saying, let's say a constitutional case, saying something's unconstitutional. Maybe it's a law passed by Congress or their state legislature or their local council. Maybe it's an action taken by the president or by a police officer. But so many cases begin with we, the people, or even me, the individual. And so a lot of those, they start in the district courts. This is the trial level court. These are federal district court judges. And this is where the vast majority of cases even end. It's where the most work is done in the federal courts, and many cases end there. How do you get in federal court? Well, one of two ways, basically two ways, I would say. One is if it's a lawsuit between people from different states. And so this is one idea here, is that the reason we have a national court system is to make sure that people in different states continue to get along. And we want to make sure, we think that national courts are going to be maybe even more fair than state courts in that situation. So that's one reason we have it. The other is that you can get in federal court if you have a question that about national law. And so that can mean the US Constitution, it can mean a law passed by Congress, it can mean a regulation passed by a federal agency. But if there's a question about federal law, about national law, it can be in district courts. And so we have the first action there, and the district court is going to say, this party wins, this party loses. And then from there, the losing party has the option of appealing to that next level of court, the circuit courts of appeals. There are 12 geographic circuit courts of appeals. There's also a federal circuit dealing with a certain limited number of items. But there, with the circuit courts of appeals, it's that next layer. The circuit courts of appeals have to accept the appeals that come before them. They don't have a decision. They don't get to say, oh, I want to take this case, but not that case. If a loser appeals to them, they have to decide that particular appeal. And so as they do that, the way that'll usually work is you'll begin with a panel, usually of 3 of those circuit court judges. They'll decide the case. And then again, someone's going to win, someone's going to lose. The loser then again has the option of trying to take it to that next level. And so what this will often mean, if they choose to go there, is they're going to file a petition in the Supreme Court saying, please take my case. This is the reason why it's important. A variety of reasons. They'll say, Supreme Court, you would need to take this case. This is called a petition for the writ of certiorari. Now, one thing to note here, Curry, is the Supreme Court receives about 10,000 of these petitions a year. So a lot of their actual time that they've taken up trying to figure out which cases to even take from all of these appeals that come before them. In the end, in recent terms, they're deciding, 60, 65 cases. So the vast majority of petitions are denied. How do the justices decide on taking a case? Well, one thing to note is, how do they have this power at all? Congress gave it to them. In 1925, Congress passed a law. It was pushed by then Chief Justice William Howard Taft, the former president. He said to Congress, it would be really great if the Supreme Court can have control over which cases we're going to take. We want to be able to focus on the ones that we really do think we need the Supreme Court to weigh in on, so we could really focus on them. And the Congress said yes. And so the court can decide yes or to no to virtually every petition that comes before them. If they deny a petition, then whatever happened in the court below, that's it. And that's the end of the story. But for those other cases they decide to take, the vote that's required is on the Supreme Court. If 4 justices say, yes, we want to take this case, it then is going to be it's going to be fully argued before the court and decided, during the course of the term. And so it's not a majority of the justices. It only requires 4. But if those 4 justices say, yes, we want to hear this case, they will then, quote unquote, grant cert, which just simply means they took that appeal from the Circuit Court of Appeals and says, yes, we are going to decide this case. And I'll sort of pause there before we get into some of the more other nuts and bolts.
So if, for a while there, we had 8 members of the Supreme Court, does that number 4 change, or is that written into the law with they can take their own case and choose their cases or not?
I think I still think it's a rule of 4 in that circumstance. I didn't really think about it, but I think it is.
Got it. And then Emily asked, is the Supreme Court allowed to take criminal cases or are they only allowed to take constitutional cases? And I was also then wondering, is there crossover between those two?
That's a great question. Now, the court can decide, it certainly decides a bunch of criminal cases. Some of those criminal cases are constitutional cases. So, a lot of the cases that the court will take that are constitutional cases are Fourth Amendment search and seizure cases. So often Americans' interactions with police officers, that's a lot of those cases under the Fourth Amendment. But the court will take a range of some constitutional cases, some cases that are really just about laws that were passed by Congress. So these would be called statutory cases. We're sometimes reviewing regulations passed by executive agencies. So some are constitutional, but some of them are falling under, either laws passed by Congress or regulations. They do them all.
So would regulations be like election laws, state election laws?
Well, no, those would be, regulations would be like when the Environmental Protection Agency puts certain clean air rules in place. They're getting that authority from Congress under the Clean Air Act, but they're then filling out what those requirements in the law mean. Those are regulations, and those can be reviewed. Those are sometimes reviewed before the Supreme Court.
Awesome. Okay. Really, I don't know if you know the answer to this. Writ of certiorari. What does the word mean exactly? Like, where does it come from? Does it mean like certification? Like,
must be Latin. I have to say, I'm not a Latin scholar, but yes, no, I'm not sure.
I was like,
the thing is, under the common law, before the American system, part of what we did was try to simplify a lot of these things, but they were just traditionally in law, like a bazillion different writs. And so like, it may go back, way into the common law. I'm not sure.
Okay, one more random question as we get into, so the case goes to the courts and they read a lot of briefs. This was one of my favorite questions years ago that one of our students asked Justice Breyer. What did they ever fight between the justices and what was their job? And what he said, I read a lot, I write a lot, and I've got briefs in my bag. And he was literally holding them. So here's the random part of these questions. How many briefs are they really reading? But do the colors matter? One of our students asked that earlier in the week. Are they color coded for a reason?
Yes, they are color coded for a reason. So I believe the white one there is probably a writ of certiorari. I think those are white. When you get to the merits brief, so this is once they take a case, the one for the petitioner is blue, I believe. The one for the respondent then is red, and then the amicus briefs are green. And I think that they're different shades based on which side you're either for the petitioner or the respondent. But these are all these crazy rules that are written out in the rules of Supreme Court practice. And you really do, when I used to work in practice, you engage with these printing companies and make sure, whether it's in the lower courts or in the Supreme Court, you're following all of those really things that may seem silly. But for the justices, if you're dealing with a big constitutional case, they can have 100 briefs. And that doesn't mean maybe they're scanning, what Justice Breyer must be right, because they have so much reading to do that so much of the skill must being able to, I think of it even in my own scholarship. It's knowing when to read deeply, when to skim, when to do those sorts of things, which are the really big ones you need to focus on. Like part of it is trying to sort through that material, I'm sure. And of course, the justices, for the 20th century, have had clerks to help them with that. But in the end, the buck stops with the justice. And so they're doing just a ton of reading, a ton of writing.
I love the color-coded system. It's my closet. That's my Post-it note system. I love it. So I get it. It makes sense. So they're reading all these briefs. They've decided to take the case. And then they go, what are oral arguments and Friday conferences? And how do these work? And maybe that really gets us into what are the behaviors and practices that they have to engage in civil dialogue?
Yeah. So again, so they get these pile of briefs. First, they get the petitioner's side. These are the people who lost below who are challenging that decision. They get the briefs from the other side. They read them for a while. They talk to their clerks. They think through the issues. And then they have an oral argument. And so oral argument, each side is going to get the same amount of time to argue before the justices. The justices will have questions. The lawyers for each side will have their own arguments that they want to make. These things aren't particularly long. They're usually under 2 hours. And so you have that amount of time to sort of it allows the justices to really give you a sense of what is bothering them or what sort of things they want to think through. And it gives the advocates a chance to say, no, this is what's really important. This is the right way to frame it. This is the key issue. These are some of the implications. These are some of the downstream effects of the other side's arguments, all those sorts of things. So it allows both the advocates and the Supreme Court to really have a dialogue. And then after that, the justices get together in their conference. And so again, that's what I talked about at the beginning. When arguments are in session, which is from October till April each year, the weeks in which there are arguments, they meet twice. And so each of those days, they'll talk about some of the cases that have been argued that week. And then they'll also decide whether or not to grant certain petitions. When they're discussing the cases, this is your great question, Curry, about civil dialogue. It's pretty cool. So they get into the conference. The custom is they will all shake hands to show respect for one another. It's a tradition. It's kind of old fashioned, but I kind of love it. Yeah, no, I think it's really terrific. And then for the discussion itself, the Chief Justice will sort of be not even the moderator, but kind of the person who keeps people on track, I would say. But the justices then speak in seniority order. So the Chief Justice speaks first, then Justice Thomas, then Justice Breyer, on. And each of them will say sort of, here are some of my questions about the case. Here are the arguments that I find persuasive. And eventually, they, from most senior to most junior justice, will give their vote. And so one great rule that Justice Breyer talks about is that every justice is able to speak once before anyone speaks twice. And so everyone, going through this formal order, gets a chance to tell the other justices how they're thinking about the case. And then once they tally those votes, we have a sense of which justices are in the majority, which are in the dissent. And then the justice in the majority, who is the most senior justice, will decide who's going to write the majority opinion. So if the Chief Justice is in the majority, the Chief Justice then decides who's going to write the opinion. That's one of the only formal powers of the Chief Justice, but it's a very important one. It helps shape whose voice is going to speak for the court. And the same will be true in dissent. That will also be decided by whoever the most senior justice in dissent is. The dissents here are when justices disagree with what the majority has said, and it could be a combination of they disagree with the results, but they also disagree with the way to reason through the case. And then finally, justices in the majority still have the option to write their own separate, what are called concurring opinions, where they may say to the majority, no, we agree with you on the outcome, but I look at this issue somewhat differently, or I think maybe we should have done this a little differently, or something like that. Or maybe it'll be, there's this other issue in the case, it's not directly on point, but I think that what we just decided decides that in certain ways. And so it's a way to sort of speak separately. But that's sort of, the last thing to know, Curry, is at that point, your vote is not set in stone. Like, you can change your vote all the way up until the court publishes the opinion. And so, people often ask, a lot of the most important cases each term, the blockbusters, they're decided in late June. And so, why is that the case? Well, part of it is it just takes the justices a lot. They really do work hard on those cases. There's often a lot of dissents and concurrences that the majority has to respond to, and they don't publish the decisions until all of the justices on each side have formally signed on to those decisions, and everyone's all set with their drafts. And that just takes time, and it takes dialogue. They're often sending memos back and forth, and you'll see sometimes the majority opinion writer, they'll be like, someone else in the majority will say, I don't agree with that paragraph. And then they'll have a dialogue about it. And so that takes time.
Yeah, and I love this kind of idea of consensus building too, that they're trying to get to the right outcome, and it's working through the drafts and iterations. And a fun part of the handshaking, so University of Berkeley did research on that and found that when you shake somebody's hand, it actually pings things in your brain that you're more likely to believe when the person tells you stuff, that they're coming in good faith. So that old time tradition is actually a really effective tool in keeping people open to listening to each other. So love those traditions, and they usually have science to back them up. It just takes us a while to prove it. Now, Tom, talking about making decisions, they're doing a lot of decisions right now and trying to make a lot of decisions on some big court cases. So I thought we could dive in deep to two big court cases that they're hearing, or they already heard this year, but they're in this process right now. Fulton, and I always feel like I say this wrong. Is it Mahoney?
I thought it was Matt Hanoi, but I don't know.
Yeah, and I just went straight to Mahoney. I don't know why.
Let's definitely talk about these. Maybe I'll just say just a quick word about the flow of the term, like where we are.
Yeah.
So the court's term, it runs from the first Monday in October. That's when they start hearing arguments. And then almost always these days, they will finish their final opinions by the end of June. So it's sort of October to June. Again, they hear arguments roughly from October to April. And so they hear arguments usually the first 2 weeks of each month during that period. And so all during that period, they're still deciding which additional cases they might add to their docket, and also sort of arguing or discussing how the opinions will come out of the cases that are argued along the way. But in the end, we see a lot of the really, really big cases are decided in June, in those closing weeks where the justices really are coming up against their own. It's a self-imposed deadline. They don't have to finish at the end of June, but as a matter of tradition, as a matter of custom, that's what they do. And that's where where there's a lot of those final negotiations over language, over votes, all of that is happening in these closing days. So these are two of the biggest cases of the term. A lot of people are following them closely. Part of the reason we're highlighting them is they're both First Amendment cases. So they're both dealing with important provisions of the Constitution. Fulton dealing with the free exercise clause of the First Amendment, so it's a religious freedom case. The other one, Mahanoy, is dealing with First Amendment free speech rights, especially in the school speech context. But just to say a little bit about each and why they're worth following closely, let's start with Fulton here. So this is Fulton versus City of Philadelphia. The two parties involved here, the City of Philadelphia on one side. Fulton represents I presume is an employee for Catholic Social Services, because really the case here is a challenge by Catholic Social Services to a policy of the City of Philadelphia. And so it's dealing with, in particular, the foster care system. And so for many decades, Catholic Social Services, along with, I think it's roughly 30 other nonprofit agencies like that, have worked with the city to screen parents for their foster care system. And so what ends up happening is that Philadelphia, as part of that process, has its own policy in place that's basically a broad anti-discrimination policy. And so because of this, it has run into conflict, as the City of Philadelphia interprets it, with Catholic Social Services and their stated policy, which is to say that that Catholic Social Services says, in the end, we believe that marriage is fundamentally between a man and a woman. And so as we're screening parents, if any same-sex couples come to us, we're not going to say that, definitely have a child there. We're just going to we're going to forward them along to a different agency. And so what the City of Philadelphia says is, no, that policy actually runs up against our discrimination policy here in the city. And so this is sort of a classic case where it's a conflict between anti-discrimination principles passed as part of a general law that applies to everyone by a government body against religious challengers, religious dissenters who are saying, no, your policy runs up against our sincerely held religious beliefs. And as a result, your policy violates the First Amendment's free exercise clause. And so that's just, you see a lot of cases that fall into this category where you see those two important constitutional and legal principles coming into conflict or being at least in tension. And furthermore, the Catholic Social Services here is asking the Supreme Court, as part of this challenge, to reconsider its landmark Supreme Court case on the free exercise clause, known as Employment Division versus Smith. And so what that decision said in important part is that it read the free exercise clause's protections relatively narrowly. So it said that, if a government passes a general law, it's neutral, it applies to everyone equally, and isn't really targeting religion, that it's constitutional. That in this case, a city could do that. And what Catholic Social Services is saying, it's saying two things. It's saying, one, City of Philadelphia, you are not treating us neutrally, you're treating us unfairly. And so they're trying to win on that argument, which is a bit of religious freedom, but also the sense that there's some animus, some hostility towards this particular religious group. They're making that argument. They say, if you don't agree with that, then overrule Employment Division versus Smith and read the protections of the free exercise clause more broadly, like you do other constitutional provisions. So anyway, those are the stakes. That's what's going on there. But it's an area of the law. It's one to watch because it's a big topic of debate among scholars, among judges, and then I think we'll see in this case among the justices of the Supreme Court.
And I'll share both cases because I do think it's really fascinating because we always talk about what could be your policy or political view and what could be your what is the constitutional question. And people split on these cases, but it's the same constitutional question that's at play. So I think it's a really fun one to compare these two. So the next court case, I think it's Snapchat and a cheerleader, right?
That's right. Mahanoy Area School District versus BL. Now it's notable because the court doesn't take a ton of First Amendment school speech cases. So we always watch these really, really closely. This is a really interesting one because it's about the intersection of school, it's a student, it's a public school, and it's social media. So it's bringing in, how do we apply an old constitutional clause and even old Supreme Court cases to this new technological context. And so here we have a freshman in high school who tries out for the varsity cheerleading team. She doesn't make it. She's very frustrated. So she goes home. I think this takes place over a weekend. It's certainly off campus, but she goes on Snapchat and she is not happy about it. So she uses some vulgarity in that. She sends it to a bunch of her friends, many of them in school with her, complaining about the school, about cheer, about, I think, softball. Like, there was a lot that was in there. But the point is that she uses vulgarity as part of this. One of the students ends up showing the Snapchat message takes a screenshot, shows it to her parent. I think her parent was a coach at the school. They share it with the school. The school decides to suspend this student from the cheerleading squad. Because she still made JV, so suspend her from cheerleading for that year. And their argument is, no, we need to be able to do this to be able to maintain sort of a team spirit, that there's a sort of a school interest in doing this. And so, this ends up being a sort of a question of, how do we apply traditional school speech principles to speech that's happening through social media that's actually being done off campus? And so the Third Circuit was the Circuit Court of Appeals that decided this case below, and they sided with the student. And they basically said they created a pretty clear line where once the student's off campus, the public school can't really reach them. And so it was a free speech protective decision from the perspective of students. But the court then takes this case, and part of it is they're hearing the arguments from the school district. And so what the school district is saying is, we have always treated speech in the school context differently than speech elsewhere. Under the landmark case of Tinker versus Des Moines School District, the Supreme Court in the 1960s there said that, students do have free speech rights in public school, but those free speech rights are not absolute, and that schools can regulate speech if it's going to substantially, materially disrupt what's happening inside the classroom. And so if speech happens inside the school, we know that that's the rule. The schools have some authority that the government doesn't have in other contexts. And so we have that. And the question here is, to what degree do we apply those principles from Tinker and school speech cases to this social media speech happening off of campus? The school district says the Third Amendment, the Third Circuit's rule can't be right. It can't be that formalistic, very clear dividing line between on school or off school. The reason why is that there are really important interests sometimes that we need to be able to promote as public schools to go at real serious problems like cyberbullying that happens off campus. And so there has to be greater flexibility in the doctrine. And so it's sort of this difficult balancing act between speech that's happening outside the classroom, but that is about what's happening inside the school and can affect what's happening in school, versus core speech that happens in there. It's a difficult First Amendment question.
And so, was there a significant disruption that happened in the school or at the practices because of this speech? That's
I have to say, I don't remember the factual context. I know that the Third Circuit, there was a concurring opinion by one of the judges there, Judge Thomas Ambrose. And I think what he said there is that I think he specifically flagged the fact that there wasn't substantial disruption. And so he said, I agree with the result of the student winning, but we could have decided this on narrower grounds, just basically saying, look, in this context, there was not disruption. Because, it is the case. You could imagine, for instance, the Supreme Court, as they're thinking about this, one big question they're asking is, do we want a really bright line, clear rule here where, if you're off campus, you're fully protected, and you're on campus, then it's Tinker? Or do we want something that's a little more flexible than that? And whenever you're creating legal rules in a situation like this, there's trade-offs to each of those approaches. And I'm sure that that's what they're wrestling with in this case.
Yeah, because there has been issues before where speech off campus has absolutely affected kids in class. And so that's where I was just trying to measure between the two with this, because I think they're bringing up some of those examples in the court case around cyberbullying and bullying in general too, and how it works with technology today. So this is a fascinating case. I can't whenever, I know we never answer where we sit on the case, but I couldn't even begin to try to answer this one. I'm like, I don't know. And that's what makes it so interesting, because it's lots of different really good perspectives on all sides.
Yeah, and it's a reminder, how did this case get before the Supreme Court? Well, the lower courts have been dealing with this issue for years upon years now. They've come out in different ways. They've come out different ways with different rules, with sometimes the students winning, sometimes the schools winning. And so it's a classic example of the court taking a case because there's what's called a circuit split. So the lower circuit courts are coming out differently. And so the Supreme Court, probably their core function, as they would look at it, is to settle those sorts of disputes and make sure that the Constitution and national law is applied uniformly throughout the country. And so a key part of what they see is not to correct every mistake in the courts below. That would be impossible. but it's to be able to take a complete look at what's happening out there, look at where there really are conflicts in how the lower courts are deciding often important constitutional and legal issues and saying, no, we're going to take that case because we need to weigh in and give guidance to all of the courts in the nation.
Awesome. This is so much fun. I love when things are right in front of us. We're on the cusp of the answers, but we're still trying to decide how we sit, what's the constitutional questions that they're grappling with, and how the system works all around it. So Tom, thank you so much. This was a really fun class. As always, I love the How Stuff Works class, and I love the current court cases. So thank you so much. Students, thank you so much for a great class, and keep an eye out at that SCOTUS blog for these cases. You can dig in deeper on them, and then also the outcomes. And I will also send the podcast that are on some of these cases as well, that our team did like a week or two ago. That's a really great podcast.
Absolutely.
Thank you, Tom, very much.
All right. Thanks, everyone.